Thank you so very much for giving us your time. And if you just joined us, this is still Enterprise Morning, reaching you from Enterprise Television. Let's head straight to our conversation for today. An Anambra-based lawyer and chairman of the Ebonyi Lawyers Forum, Victor Alo, has criticized the life sentence given to IPOB leader Mazi Nnamdi Kanu, calling it a par incuriam judgment. He argued in Nkpor that the Federal High Court should have first decided the issue of jurisdiction raised by Kanu before ruling. Alo also noted that the Terrorism Act used in the trial had been repealed, insisting that the conviction based on defunct law violates the legal maxim ex nihilo nihil fit, which means that nothing comes from nothing.
Very true. He further questioned the evidence presented, saying no weapon was tendered and nothing proved Kanu's involvement in terrorism beyond reasonable doubt. Alo acknowledged that Kanu's conduct in court was sometimes confrontational, but maintained that behavior cannot replace concrete evidence. He added that none of the alleged perpetrators of violence had been arrested or made statements linking Kanu to the acts.
Also, Alo expressed optimism that the Court of Appeal or Supreme Court would overturn what he called an unsustainable verdict. He also suggested that President Bola Ahmed Tinubu could grant Kanu clemency as an alternative measure to ease tension and promote stability in the southeast of Nigeria.
Yeah.
We still have Barrister Vansufeli. Barrister, thank you so very much for your time and hanging on.
Well. Yeah.
All right, so let's get talking on this issue, which I would love to believe the shelf life is still very, very active. We might discuss this issue around the country for as long as it remains. But let's get talking on the legal issue now. All of those things that your colleague stated there, some of them are Latin words and all. I would love you to help us break it down, please, so we understand where we are and many more.
Yes, there's an absolute miscarriage of justice in that case. There's a miscarriage of justice because if you look at it, ex nihilo nihil fit, nothing comes from nothing. You cannot pull something from nothing. Nothing is equal to nothing. Okay. It's a judgment that is delivered par incuriam, which means that the judgment itself did not follow the basic legal principle for which it ought to have followed. Now, when you look at the spread of the case, there are three fundamental issues. First, the law upon which he was charged had been repealed. Okay, so the statutory absence of the existence of that law itself foils that issue. Okay. Two, the objection raised by Nnamdi Kanu in terms of the objection that relates to that the court lacks jurisdiction to that effect was not adhered to by the judge. Primary objection under the law, once it is brought, the law says that it can be raised at any point before judgment. So, and once it is raised, the court must first of all suspend whatsoever it is doing to attend to that. When the issue of jurisdiction is raised, the court must first of all assume jurisdiction to determine whether it has jurisdiction or not. That was not done. Okay? Then the third one has to do with proof beyond reasonable doubt, the material evidence, the nexus, that the unequivocal evidence that's supposed to link Nnamdi Kanu to the charge was not there. Like the lawyer said, there was no weapon. Even when you go beyond that, there was nothing direct. You are saying he made this statement, he made that statement. All those whom were affected, nobody was called as witness to testify. So the court solely relied on circumstantial evidence under the Evidence Act. Circumstantial evidence requires corroboration before it can be fit for conviction. Okay? So when you look at the case in its totality, these three defects deflate the argument put forth by that judgment for the conviction of Nnamdi Kanu. In criminal cases, the law says that you cannot charge someone for an offense not known to law, and you cannot charge someone for an offense that is not in a written law. Okay, so if you are charging someone on a law that has been repealed, and you have that in your charge sheet, what you need to do is to first of all address that as a prosecution counsel or the prosecution team, which was not done. Okay, criminal trial requires proof beyond reasonable doubt. It is not enough to say he made statements. To whom did he make the statement? Where are the witnesses? Where are the evidence? Okay, upon his conviction, on what basis are you arriving at his guilt and thereafter his conviction and sentencing? Okay, so we don't, in law, you cannot, apply speed and kill it on the altar of technicality. So the court, I absolutely agree with the lawyer that that judgment is sitting on a very wrong tripod, because by the time you clear those three angles, aforementioned angles, there's nothing left of that judgment. Because it is political, perhaps there is a pressure to score points, but the law does not see it that way. Whether a matter is political or not, even if a matter is political, it must conform to legal process, legal proceedings. If a defendant is raising an objection, you don't say because you want to deliver judgment, you want to end the case, you go ahead and deliver judgment. When in section 36 of the 1999 Constitution, it says that the defendant must be given adequate time and facility to prepare for his defense. There are times when a judge
he was given more than enough opportunity.
No.
Especially when he said he wanted to defend himself. The judge kept telling him
when he filed the objection, the motion to challenge jurisdiction, the judge refused to hear the motion. He was given enough time to enter his defense, but he opted for a motion.
So what's the difference?
To challenge the jurisdiction. Yeah, there's a difference.
Yeah.
Okay.
You are asking him to open his defense. That's to call his witnesses that he has listed. He listed many of them. You're asking to call them and have his case dispensed with. You understand? You gave him enough adjournment on that. In the process of that, he came up with a motion. He brought out a motion. He filed a motion and said that I am challenging the jurisdiction of this court. It's allowed in law. Objection can be brought at any point before judgment.
Wow.
Yes. There are times when a judge has written a full judgment, has adjourned to deliver the judgment, and will file motion to arrest the judgment. It's allowed in law. So what will now happen is that instead of the court to go ahead to deliver that judgment, the court will suspend that judgment, the substantive suit, and focus on the motion filed. Okay? And then deal with that motion to its conclusion before it goes back to the judgment. That is the law. Okay? So if that was not followed, would you still say that the judgment is sound on that? See, Judgment, however sound and brilliant, that is delivered by a court that lacks jurisdiction goes to no issue. Ex nihilo, nihil fit, from nothing comes nothing. This judgment cannot be an exception. It cannot be because lawyers just kept quiet. You can't. This is the first judgment that we are putting something on a nothing and expecting it to stand. It cannot stand. This has nothing to do with emotions. And the fact that a defendant is unruly in court, uncultured and mannerless, does not give the court, does not give the court, does not empower the court to pass judgment against him. There are other options the court ought to have turned to by contempt, you know. The court will have charged him for contempt or any other remedy available to the court. So because I've heard people say because he was unruly, that is why the court had to quickly. That is judicial blasphemy. To convict a man because he's unruly. No.
See, it's actually interesting, Barrister, you're saying. Yes, Barrister, sorry to cut in here. It's actually very interesting as you fleshing out some of these things and expose them as much as you can. But as a lawyer, is it fair to say that at this point you are questioning the intellectual dexterity of Motosh or SAN at this point, and knowing what he had going on?
Very well. What do we do on appeal? I can talk like this now because the case has ended and they have not filed appeal. They are filing today or tomorrow. The reason lawyers cannot talk outlandishly before night because the matter is sub judice. Right now, it's no longer sub judice. And when we go on appeal, what do we say? We say, see how we couch appeal. Let me tell you how we couch appeal. The learned trial judge misdirected himself. That's how we couch appeal. When he concluded or made so that's how you couch appeal. The learned trial judge erred in law. Do you understand? So that is it. So you will see that the appeal will be framed around these three premises. It's a criminal matter, it's not a civil suit. Criminal matters that the penalty is capital. You don't treat it with kid's glove. The fact that Nnamdi Kanu unwittingly said he was going to defend himself does not change the procedures and principles of law. The procedures and principles of law, they still stand. Jurisdiction is a threshold issue, is a hallmark of litigation. When a court lacks jurisdiction, it lacks everything. And one thing the law forbids is that you can't pull something from nothing. It will not work.
You are shaking the table at this point, and
yes, that is what it is exactly. The public need to know. I have an article already that will be published in Sarah Reporters in the next 1 or 2 hours, which I wrote last night. That judgment, I didn't even know it's going to coincide with what I'm going to talk about this morning. Okay, so the law have processes and procedures. That is why it is not a sound judgment to allow non-lawyers to dabble into to say I want to defend myself. It is not, because let me tell you, if Nnamdi Kanu had allowed Kanu Agabi to even do this defense, these whole issues would have been very difficult for the court to even convict in the first place, because they were brought up salient issues. And it's not enough that people died. You must link that death to an act of terror. And you must link that terror to the defendant. You understand? Somebody said somewhere, made a broadcast somewhere, that you you do this, you do this, do this. Then you interpreted it to mean he incited people. You understand? Then you did not go further to prove it by saying that incited people, these are the persons that are affected, these are their testimony, these are the witnesses, this person you affected in this particular place, the broadcast led to this, and the rest of that. You are just saying from here that it was the broadcast that led to the killing of police at the NSAS, or the broadcast they just led to which police was killed during the NSAS. So please, we can't just sit back and say no. Hardly will you find a lawyer that supports Nnamdi Kanu's approach and his conduct and his character. His character is distasteful. His conduct is overbearing. The way he approached matter is not acceptable. But on this issue of his trial, the prosecution hadn't proven his case. The prosecution hadn't proven his case because the prosecution is supposed to rely on the strength of his case than rely on the weakness of the defendant's case. Mm. What they did, all the evidence they tendered and the rest of that, they were not disproved or rebutted. That is why the court went that direction. And even when the court went that, the court still erred by going that direction because jurisdictional issues were pending. Lack of proof beyond reasonable doubt, the standard in criminal matter, was not adhered to. And so you can't just rush because you want to convict and then conclude that it's a complete miscarriage of justice, to say the least.
Wow. Okay. Thank you for that. So, can a life sentence stand if no arrested perpetrator linked Kanu to to the alleged crimes? Can it still stand?
Can an arrested what?
Can a life sentence, he was given a life sentence, can a life sentence stand if no arrested perpetrators linked Kanu to the alleged crimes?
That is part of what was saying, that for now, the court has reached its own decision. Do you understand?
Yeah.
If Kanu does not appeal, this judgment will stand. Do you understand? However erroneously delivered and not considering the full principles of law. But if this judgment is appealed, which is probable, you understand, it will not stand because of the legal error made by the court of first instance. So the court of appeal will have to look at those grounds of appeal vis-a-vis the laws that establish them, the laws that they are going to back them up with. And the court of appeal will take a decision whether the court of first instance did the right thing or it erred. At appeal, nobody's calling witnesses. It's a jury court. The court of appeal is looking at the decision taken by the court of first instance, the reason behind the decisions, okay, and the legal consideration of law that was applied by the court to the fact of the case. Where they are wrong, the court of appeal will point them out.
All right.
Okay.
And take a decision.
Understood.
All right. So let's just take a look at some comments from Nigerians who have written here. We have one Chalo T2X who said, the people sharing Nnamdi Kanu's broadcast on social media are the ones inciting the public. So it's not the creator, the content creator, but those who share it. That's what this young man is saying.
Yeah.
And another person said, that is Anthony, said, Mazi Nnamdi Kanu is a prophet. He called him Jesus of our time. God bless Mazi Nnamdi Kanu and Simon Ekpa. and one Dr. Ngozi in the United States of America. So let's get to this matter. I truly do understand that every nation comes with its constitution, the way it should do things, law and all that. But I'd love to know if this is a universal application, especially with regards to the evidence that you shared, that if someone makes a broadcast and there's no evidence that really shows that the person physically was part of what he has said, that he has no case. But in the case of Simon Ekpa, that's Finland, he was judged on the premise of all the things he said, just like Nnamdi Kanu, and jailed for 5 years plus. And equally, let's take this, let's take this equally to Rwanda. During the genocide era, a young man, a broadcaster who was saying, kill the cockroaches, one Kachagwa, he made himself to Canada and was repatriated back because the Canadian people said, no, we can't stand this. You can't just make statement, and as a result of that, people kill people. These two individuals, Simon Ekpa and this man from Rwanda, they didn't actively participate in it, but because of what they created led to so many issues. In the case of Nnamdi Kanu, don't you think it equally should apply?
Yeah, I didn't say that he made those statements and because he didn't physically come to, no, that's not what I said. Inciting people under our law is an offense. It's an offense by the Terrorism Prevention Act and the Criminal Code. Okay, it's an offense. But I'm saying that offense is not just by expression. The prosecution must prove the offense. The prosecution must prove the offense. That's what I'm saying. And if the prosecution is not able to prove the offense, what it means is that the court cannot convict. Because, see, when you say somebody incite, what do you mean by incitement? Is it by just framing a charge sheet?
Because
are you not supposed to call witnesses? Are you not supposed to call witnesses, those who are affected thereafter, as a byproduct of what has happened? You understand? So if that is not proven, and you just rely on circumstantial evidence, and you are convicting somebody for life, does it make sense to you? That's what I'm saying. So the standard of proof under our criminal law is beyond reasonable doubt. You understand? You have to establish it beyond reasonable doubt. So if you have not done that, if you have not established it beyond reasonable doubt, you cannot validly say that the person is guilty of that offense of incitement. That's what I mean.
All right. Okay, so let's hope that all of this is quite, received by people who might not understand this and more. But the family of Nnamdi Kanu have said that his taken way to Sokoto is not good enough. Do you think? Yes. Do you think it's in our laws? It's okay for people to say or direct where people should go to?
Like that, whatever you can do is persuasive. You can say because the matter is in Abuja and he wants to file cases, he wants to file motions and all that, it will be difficult for him to file and all that. You can put up all those arguments, but you cannot decide the prison custody that the defendant is being taken to and all that. It can only be persuasive. Sorry, the convicted person now is taken to. It can only be persuasive.
Okay.
Okay. What impact could a possible clemency from President Tinubu have on national stability? So I just thought of linking this story to this particular question.
Yes, clemency would normally, one of the grounds for which President grants clemency is if there is miscarriage of justice. If the matter has political coloration that requires stability and so many other considerations. Okay, the president can do that, and that cleans the the entire conviction and everything.
My last question is this, because you talked about circumstantial evidence. So I went searching, because of course there are lots of information here and there. And what I have here says that circumstantial evidence is sufficient for conviction if it forms a complete and unbroken chain that points exclusively to the guilt of the accused, excluding any other reasonable hypothesis of innocence. So, does this make sense? Yes.
Yeah, excluding any other reasonable hypothesis
of innocence.
It can only be relied on if all the arrow points to the person.
So, is all the arrow not pointing to Nnamdi Kanu?
No, he made a broadcast, you understand?
Yes.
But the thing is, have you proven beyond reasonable doubt that the broadcast incited people and the incitement led to the death of soldiers and policemen and all that? He was saying, if you see the Nigerian police, attack them, attack the army, kill them. Do you understand me?
Yes.
Then you need witnesses to accentuate how many soldiers were killed.
Oh, okay.
Where were they killed? When? Is it before the broadcast or after? You have to link those deaths to that broadcast unequivocally. That's what I'm saying. First of all, were there any deaths of soldiers?
Yes, there were many.
Yeah, that's what I'm saying.
Yes.
Then, where? When? They will bring evidence. Even if if people died, who died anywhere, you cannot ascribe all the soldiers that died within that period to the broadcast. You have to prove it. That's what I'm saying. And we're not done.
All right, we have to prove it and all. So we just hope that this is a developing story, and we promise to bring them to you as they unfold. It's a very tough one. Of course, I said the shelf life is still open. We keep speaking about it, talking about it, and hopefully the appeal will be made either today or tomorrow, like Barrister did say, and lots of other stories will come up as this unfolds. Lots of learning for us journalists, and equally for students of law, to understand all of this, and hope that that all of this would work. And Barrister, just before we let you go, what do you think the NJC is doing now? Do you think they are standing in as spectators, or they don't have a hand in any of these things, knowing what you said about the court really not doing the right thing?
I didn't get the question.
I said the NJC, do you think they are standing in as spectators, knowing all the things happening and what lawyers are saying against the judgment and all? What do you think should be...
Well, the NJC, they'll take judicial notice of what is going on, and at the right time, they will do what they are supposed to do by law.
All right. Okay, people, that's just about the time we have. Thank you so very much, Barrister, for your time. We truly do appreciate you and your insight. All right. So, people, thank you so very much. So, we have to leave now just to make room for other interesting programs coming up in a minute. But please do well to follow us. If you may, you can find us at enterprisetvnews.com. You may equally like, comment, and follow us on all our social media platforms at Enterprise TV7. I am Henry Igwebike.
And I am Kendi Boduri.
Have yourself a splendid day. God bless you. God bless Nigeria. We'll see you soon.
Bye for now.